The Ripple top legal officer, Us.Thankx, has spoken out against the SAC's demand for a $2 billion fine and an ongoing lawsuit against XRP. Both of these demands are being made by the SAC. In the midst of Ripple's preparations to contest this hefty sanction, the regulatory confrontation begins. Is this supposed to be a significant event for XRP Ripple? As the legal drama unfolds, make sure to keep an eye on the news for any new information. Please remember to follow, like and share this post. Let's get started. There is some unfortunate news to share. The SAC intends to levy a fine of $2 billion against Ripple for selling XRPs to institutions. Ripple's chief executive officer, Brad Gullyhouse, has made these statements. We could see that the majority of this is the cryptocurrency XRP, which is settled on both Corda and Swift. This was written in the Corda code, which is also written in Swift. Within the code, we were able to observe our three Corda finances: Ripple, XRP Payment, XRP Settlement, XRP Oracle Service, Swift Service, and Swift Payment Status Type. The fact that it is a talking type makes it quite cool. Although I do not fully understand what it implies, I am aware that something is taking place behind the scenes. The SAC is demanding that Ripple XRP pay a fine of $2 billion. In spite of his efforts, I believe that it will move up in the near future. The Chancellor's SAC has been found guilty of breaking the law on numerous occasions, and judges have issued warnings to the agency, stating that it is abusing the authority that Congress has granted it. That is the case of the box, and the case of the Ripple is for operating in a manner that does not adhere to the norms. In addition, let us not overlook the fact that the Chancellors did not provide any consideration to the SB fraud. SAC was punished with a punishment of $2 billion, according to the chief legal officer of Ripple. Also, this is the one that we are going to go for next. Within the context of the XRP case that has not yet been resolved, the United States Securities and Exchange Commission (SEC) has very recently submitted a remedies brief. The silence on the topic was broken by Us.Thankx, who is the chief legal officer of Ripple. Ripple's chief legal officer Chloe condemned the inappropriate expectations that were placed on the X platform in the XRP dispute. One of the most significant aspects of the SAC's remedies brief was disclosed by Us.Thankx. In the document, the royal leader requests a total of $2 billion in fines and penalties. Us.Thankx has mentioned that a company that deals in blockchain payments will submit its response in the month of March. The corporation will make the case that the United States Securities and Exchange Commission (SEC) is a regulator that regularly makes assertions that are incorrect and misleading. The chief law officer of Ripple stated that the market regulator adhered to the form that it provided to them. A statement made by Us.Thankx indicated that the SAC has not been adhering to the guidelines. On the contrary, it has made up its mind to penalize and intimidate Ripple as well as the industry as a whole overall. During the remedies portion of the case, Us.Thankx expressed his belief that the court will be impartial. XRP that is exchanged on trading platforms by private traders does not meet the criteria to be considered a security, according to a decision made by Judge Analisa Torres in July of the previous year. That was a victory for Ripple as well as for a United States SAC. When the payment corporation sold XRP to corporate investors, Judge Torres stated that the company had violated the rules governing those transactions. For the XRP community, this is a significant victory. Throughout the course of the last few months, there have been a number of legal debates concerning the procedures that will decide the manner in which the ongoing trials are conducted. One of the agreements that these parties have reached is that any significant information on the procedures ought to be kept confidential in order to safeguard the credibility of the discussions. It is still their responsibility to pay for what they have done. In July of the previous year, when the verdict in the XRP case was handed down, there was a lot of discussion regarding the amount of money that Ripple Labs would have to pay to remediate the portion of the law that it had violated. The first demand of $2 billion made by the SAC, on the other hand, did not come as a surprise to market experts. On the other hand, veterans such as John Dayton, who represents XRP holders, have pointed out that the company would pay a significantly lower amount, regardless of how the negotiations help reduce the amount of the fine demand. According to the opinions of the experts, Ripple Labs will still be required to pay in order to resolve the dispute. In addition, Ripple has incurred significant costs in connection with the XRP case. According to a report that was published previously by CoinGate, the total amount of the legal bills has exceeded $200 million. The next one is Terraform Labs, which is being tested because SAC considers it to be a false monarchy. In the beginning of the civil case that the United States Securities and Exchange Commission was bringing against Terraform Labs, the SEC stated that the blockchain company was a fraud. The Southern District of New York is the location of a court case that, according to attorneys representing SAC, Terraform Labs was a financial catastrophe in which investors lost a significant amount of money. The Securities and Exchange Commission (SEC) filed charges against Terra and its co-founder Do Kwon in February 2023, accusing them of committing a fraud on crypto-asset securities that was worth many billions of dollars. More than a year later, the trial finally got underway. According to Devon Terrain, who is a member of the SEC, Terra was comparable to a house of cards that collapsed on its owners in the year 2022. In the fight against the scam that led the cryptocurrency market to plummet in a significant way, exactly like Terra USD, this case marks a turning point when it comes to the fight. Terra, Luna, and other stockings suffered losses, which led to a chain reaction of losses for a number of cryptocurrency companies. Defendant Bieber and the DeFi Education Fund filed a lawsuit against the SEC. A lawsuit has been filed against the Securities and Exchange Commission in the United States by the DeFi Education Fund and the clothing manufacturer Bieber, which has its headquarters in the state of Texas. This court is located in the Western District of Texas Judicial District. In the complaint, the SEC's regulatory approach to digital assets, particularly the manner in which it has classified certain tokens as securities, is called into doubt. There is now a legal dispute regarding the classification of tokens. This legal action is based on the Bieber token, which is distributed by Bieber through the use of airdrops. The plaintiffs argue that these tokens, which may be used to purchase exclusive things in Bieber's online store, should not be considered securities because of the manner in which they are issued and the manner in which they are used, which does not satisfy the Howey test. This serves as a form of protection and is utilized by the SEC in order to determine whether or not an asset is an investment contract. These conditions are not intended for Bieber airdrops, as stated by both Bieber and the DeFi Education Fund. This is due to the fact that their tokens are distributed at no cost, and there is no expectation of making a profit based on the efforts of different individuals. A shared enterprise that will produce money from the efforts of other people is the subject of the Howey test, which asks how much money should be invested in such an industry. In addition, Ripple's circumstances are improving as the month of April draws nearer. Investors have taken notice of Ripple as the month of March draws to a close since the cryptocurrency has demonstrated a 10% increase. Investors are eagerly anticipating the month of April, keen to see how the digital currency would do, as the value has remained at 64 cents. This positive trend has investors interested. This month, XRP experienced significant historical gains. According to the historical trends analyzed by CryptoRank, the performance of XRP in April might witness a 30% increase. In spite of the fact that XRP has performed nicely this month in the past, despite the fact that one forecast indicates that the average return will be 31%.